Good afternoon. I'm very pleased to be here, and I would echo something that Tom Devine commented on, which was that I'm very impressed with the level of the discussion that has already taken place here in Italy, and it's a pleasure to see how far along you are in this discussion about whistleblowers and about the laws that exist in the United States, as well as what you can do here in Italy. I'm going to focus on one statute, the one that you've heard the most about already, which is the United States False Claims Act. And that's the one that the ambassador had such a powerful effect in bringing about the amendments. And then Erika Kelton is going to speak about a couple of other United States laws that are much newer and that have some very different features. And so you might look at both sets of laws with an eye to whether or not there are pieces of each one that are relevant for the situation here in Italy. We're not going forward. What do we do? Is there an on-off switch? Yeah, I did. We have one slide. I could stand at an angle, but I'd like to have it work. Well, there we go. So, as you know what a whistleblower is, someone, and I agree, it's an individual or corporation that comes forward with information and brings them to the appropriate enforcement authority, which is a very important aspect of what we are talking about in terms of whistleblowers. This is the heart of the False Claims Act. You've heard this referred to. It's something that is very powerful in terms of the ability of the private citizen to bring a lawsuit on behalf of the government, which is a very important and unusual aspect of this law. I heard the discussion about the constitutional issues in Italy. In our situation, because this law actually came from the history in common law from England, and it predated the United States Constitution, this concept, that was the heart of the statute, the ability for a private person to file such a lawsuit. That's the heart of why the lawsuit, this type of lawsuit, is considered constitutional in the United States because it dates back before even our Constitution existed. The law was enacted when the federal government during the Civil War was finding that the horses that they had ordered that were being delivered couldn't walk. The sugar that they were supposed to be getting, or salt, was sand. The government was receiving defective goods, and President Lincoln and his cabinet realized that they did not have the resources to police the vast amount of fraud being committed against the government. And so they turned to this concept of vastly expanding the power of government beyond what the government itself could afford by bringing in private people to file these lawsuits. And that's one of the key features of this. And I think it's also one of the considerations that you should have in mind with respect to the concept of the reward, because sometimes we think about the reward only in terms of the factor that makes somebody come forward because they're looking for a reward. But it's much more than that, because it actually provides the resources for the private attorneys and the private sector to expand the ability of the government to go after fraud. So these are the amendments that Ambassador Phillips was so involved in bringing about. The incentives were improved dramatically. The whistleblower was guaranteed that if there was a successful recovery for the government, that some part of it would go to the whistleblower. The whistleblower would be able to go ahead with the lawsuit, even if the government, after its investigation, decided not to go forward. the whistleblower did not face any expenses because the private sector would put forward its own resources to support the case, and then when the case was successful, the defendant would pay the attorney's fees. And this issue that has been discussed in a very informative way about what do you do to protect the whistleblower, the person who has come forward as a whistleblower has their own ability to go to court to file a lawsuit if, in fact, they are discriminated against or fired or reduced in their status. Another important aspect of this law has to do with the way that the lawsuits go forward. So this is a lawsuit. It's filed in court like any lawsuit, but it has one unique feature, which is that the defendant does not know that they have been sued. It's filed under seal, and that gives the government a chance to take a look at the claim to see whether or not it's worth going forward. That's a very important step in the process, and as I'll mention again in a minute, that's part of what protects legitimate corporations, legitimate interests from being unfairly attacked because the government has to conduct this investigation. The law applies across a wide variety of kinds of activities, anything that can involve fraud that is against the government. And healthcare, my field, healthcare, unfortunately, is a prime example of where there has been a lot of fraud. And the defense contractors for the military and a wide range of other kinds of activities are all the subject of this law. Oops. Okay. Now here's the results. So these amendments went through in 1986. Before that time, it was averaging about 6 of these cases every year. Since then, over 15,000 such cases have been filed. Before 1985 in the amendments, the recoveries were running, as you heard before from the ambassador, in the millions, $27 million or so. Since then, and this is the grand total, you've heard several different numbers, but the grand total, if you count all the money that was recovered in civil lawsuits, all the money that was collected in criminal proceedings, and all the money that was recovered for the state governments as well, because it's not just the federal government that has this type of law. It's over $70 billion already that has gone back to the various levels of government since the amendments. So that's how important these amendments from 1986 were. And this is the other point that the ambassador mentioned. If you look at where the government's activity in fighting fraud comes from now, if you look back before the amendments, the blue lines show you the investigations that were not based on whistleblowers that the government was undertaking. And if you look at the more recent years, the vast majority of what the government is doing now in terms of government fraud investigations come from whistleblowers. So this has been successful not just in terms of the dollars recovered, but also in terms of focusing the government's activity in a particular direction. Now, this is the heart, as you quite clearly already understand, this is the heart of the kind of law that we're talking about. 2 things, incentives and protections. Incentives for the whistleblower to come forward, but also incentives for the government to do something about it. Protections for the whistleblowers, but also protections for legitimate companies that are not engaging in fraud. And I'm presenting the way that the False Claims Act deals with these features, and then Erika Kelton is going to talk about some variations on how this is achieved in the other statutes. So the incentives, of course, give people the opportunity to get a financial reward, and the whistleblowers, since the law was amended, have shared a grand total of $5 billion in rewards have gone to whistleblowers. Whistleblowers don't foot the bill for the investigations. They work with private lawyers, and they have the private lawyers helping them deal with the government, which is a very important aspect of their willingness to come forward so that they are not facing a government bureaucracy all alone. If you look just at the civil settlements, the vast majority, I said about the money that went to whistleblowers, but the vast majority goes to the government. At the very bottom of this slide is another important feature that Ambassador Phillips mentioned, that this program is very efficient. We've had the most recent study has shown that the government has recovered $20 for every $1 that it's spent on running this program. So the return on investment is about 20 to 1 in the most recent analysis. So it's a way of giving government many more resources at its disposal without increasing the federal budget to spend in this area. So again, about 84% of the recoveries go to government, and about 16% have gone to whistleblowers. And if you, this is also to give you a sense as to the distribution. On the left-hand side are recoveries in civil lawsuits. Then in the middle, the amount of money from criminal lawsuits. And then next to the grand total, the amount that's gone back to the states. So everybody, so all aspects of this law are working, and they're working together to promote effective ways of dealing with fraud. And this is what I mentioned a second ago. If you look down here, that little green bar is how much is spent to operate these programs, and the three large bars demonstrate how much is collected, and so it adds up to about 20 to 1. Now, incentives for the government to take action. Already talked about incentives for the whistleblower. Incentives for the government to take action. I think the next slide illustrates one of the big incentives for the government to take action. This is good press. This is good government out in the press. This shows that the government has done something. This illustrates the effectiveness of the kinds of activities that we're talking about when you can get headlines like this, and every one of these big cases makes good news. So not only is the government getting a very large amount of money that it would, by definition, never have gotten, but it's also making itself obvious to the public that it is doing something worthwhile, and it is holding people who have committed fraud accountable. The protections for whistleblowers in the False Claims Act protect employees, contractors, and agents from all the things that you've been concerned about: discharge, demotion, suspension, threats, harassment, or other discrimination. And the whistleblower has the right in this statute to enforce those provisions. So very powerful protections for the whistleblower. If the whistleblower has suffered any kind of discrimination, the whistleblower can bring a lawsuit to look for reinstatement with double back pay plus interest, and with special damages, including any costs that they have borne. So this has been a very useful aspect of the False Claims Act in terms of whistleblowers being willing to risk their careers and to risk their incomes and their livelihoods by becoming a whistleblower. Legitimate companies do need to be protected against frivolous lawsuits. There are standards for when an attorney can file a lawsuit in the first place, the amount of information that the attorney has to reasonably be able to assert before the court. That's a very fundamental requirement. There are very high standards in terms of the level of information that the government has to find before it's willing to go forward with the case. And this third bullet is very important because the legitimate companies that are doing the right thing deserve to not have unfair competition by companies that are cheating. And so it's a big incentive for legitimate companies that they know that they are being protected against unfair competition by their competitor down the street that is committing fraud and thereby gaining an upper foothold against them. So as part of the standards that have to be met, the cases only go forward if there's been a financial harm to the Treasury, federal or state government. And there are different definitions for how you can define that, different ways that the money can be fraudulently obtained, but the core issue is whether or not one can show that these actions caused harm to the government that should not have occurred. These are more protections for the legitimate companies. If you're just a simple violation of a rule or regulation, that doesn't trigger this particular statute. So that's a big protection for the companies. And a lot of times companies will say, I think we heard this a little earlier, oh, we didn't know what we were, that was the ambassador's comment about the companies that would say, we didn't know what we were doing. But the standard is that there has to be demonstrable behavior on their part that did cause harm to the government in a financial way. And this is my final slide, just to show you that in the United States, the False Claims Act has been very successful at the federal level, and so far, 29 other states have adopted a similar kind of statute. And so they are protecting the state spending in the same way that the federal government is protecting its spending under the Federal False Claims Act. So, two-thirds of the, about two-thirds, not quite, of the states now have statutes like this, and it's a very important tool for many states, and you can see that some of the bigger, more populous states have these statutes as well. So thank you very much, and I'll turn it over to Erika, and then we'll take questions later.
Thank you, Peter. Thank you. And thank you all for having me here. It's really a pleasure to be part of this very substantive dialogue between our countries on this very important subject. I became a lawyer in 1987, and early on I began working with Ambassador Phillips on False Claims Act cases when the amended law was really in its infancy. And at that time, I don't think we really foresaw where this law would be applied or where it would go. At the time, we were really concerned with the kinds of cases that your client, Tom, Ernie Fitzgerald, were bringing forward. Those were defense contracting cases. The prototypical one was, the government spending $500 on a hammer that it could have purchased at the local hardware store for $5. Since the amendments, as Peter mentioned, we've expanded beyond defense into healthcare, into pharmaceuticals, into telecommunications, into infrastructure, even cases involving library books, believe it or not. Now, I want to turn and discuss the latest expansion of federal whistleblower programs, and it has to do with financial fraud enforcement. As the ambassador mentioned, in connection with the Dodd-Frank Act in 2010, Congress adopted 2 whistleblower programs embedded in that massive legislation. They concern programs for the Securities and Exchange Commission, the SEC, and the Commodity Futures Trading Commission, the CFTC. And I'm going to use those acronyms throughout because the full names are really quite a mouthful. There were really two primary motivations to adopt these reforms, and Ambassador Phillips, I think, mentioned both of them, but let me just go back over them. One was as a response to widespread fraud and regulatory failures that led to the 2008 financial collapse and crisis. And then the other, really at the same time, was disclosure of the SEC's repeated failures to follow up on information provided by whistleblowers. And the central case that's really shown as an example is the $65 billion Ponzi scheme that was run by Bernie Madoff, which injured investors around the globe. Now, in that case, over a decade, at least a half a dozen whistleblowers had gone to the SEC to alert them to Bernie Madoff's scheme. And in one instance, there's one fellow who's now the subject of a feature film, Harry Markopolos, who went about half a dozen times himself. The SEC did not take action. So in this context, it created an environment for reform, and Congress was willing to act in the context of the Dodd-Frank Act, and it looked to the success of the False Claims Act to enact a whistleblower programs for both the SEC and the CFTC. Now, unlike the FCA, the False Claims Act, which covers limits liability to frauds against the government. What's interesting about the SEC and CFTC programs is that it covers any violation of either the securities laws or the commodities laws. So the Whistleblower Programs Act is kind of an overlay on the legal regime in those areas. As a result, the scope of application of these programs is massive. It covers everything from financial accounting frauds to misvaluations of funds to manipulations of equity prices or rate manipulation of commodities and to Foreign Corrupt Practice Act violations. Like with the FCA, one of the central features of these programs is that they offer mandatory financial rewards in successful cases. And like the False Claims Act, the range of awards is quite similar. It ranges from 10 to 30% of the amounts recovered by the SEC or the CFTC as a result of the whistleblower's information. A fairly unique feature is that it doesn't just limit it to the amounts that those agencies recover, but amounts recovered in related actions by companion prosecuting entities such as the Department of Justice or even the New York State Attorney General's office will be included in the basis of a whistleblower's award. I actually want to step back in time to show you kind of a before-after snapshot of why we feel mandatory financial incentives are so critical to the success of a whistleblower program. It's little known that for about 20 years before the Dodd-Frank Act was passed, there was a very small whistleblower reward program concerning and limited to insider trading that the SEC ran. But in that instance, the awards were totally discretionary. They ranged from 0 up to a maximum of 10%. That meant that a whistleblower who stepped forward with potentially valuable information and who risked his or her jobs and even, could befall, have, personal, risks as well, had no guarantee that they would be rewarded even if the agency was successful. from our perspective, the result wasn't really surprising. In 22 years, only 6 very small cases were submitted to the SEC, and it recovered only $10 million. That's in over 20 years of this program. I'll get to this later, but what we'll see is that the SEC in 5 years is now getting several thousand submissions a year and has already recovered well over $500 million. And I actually think that the total amount recovered is probably closer to $1 billion, which is, you know, a record of a very young record of success. I want to quickly go over some of the basics, some of the nuts and bolts of these programs. First of all, to get an award, the SEC or CFTC has to recover a minimum of $1 million. And the reason for this is that it's really for ease of administration. They don't want to be burdened with a lot of $5,000 awards or $50,000 awards. So it's for streamlining the administrative burden. And also, as I mentioned, recoveries in related cases by other prosecuting authorities are included in the basis of a whistleblower's award. So let's say the SEC pursues a Civil Foreign Corrupt Practice Act charge against an entity and recovers $50 million. Well, as quite often is the case, the Department of Justice will have a companion criminal action. And so let's say the Department of Justice recovers $100 million in the FCPA case. That would mean, in this hypothetical, that the whistleblower, the basis for the whistleblower award, would be the $150 million, and that whistleblower would, if he or she qualifies, would get 10 to 30% of the $150 million. Another unique feature of these programs is that, unlike the False Claims Act, where the whistleblower's award comes out of what a defendant pays to the government, that's not the case here. There's a separate fund that was created from sources other than these recoveries to fund whistleblower rewards. And the reason for that is that Congress felt very strongly that investors who are harmed by wrongful conduct should be made whole, and that if you fund a whistleblower award out of the monies that are recovered, then it's going to come out of, in a sense, the investors' pockets. So they're funding these separate award funds from separate sources. The amounts are remarkable. I mean, really, they're jaw-dropping. The SEC has over $400 million in its award fund, and the CFTC has over $250 million in its award fund. And by the way, these are not amounts that will ever be depleted. There is a mechanism to have them constantly replenished. But I think it's important to tell you those amounts because I think they really speak to how significant whistleblower fraud cases and the whistleblower approach is regarded by the agencies and by Congress, and how successful they believe that they will be. So I now want to turn to which whistleblowers are eligible. So there are a few requirements to be eligible for an award. First of all, the information that the whistleblower provides has to be based on either his or her independent knowledge or an independent analysis that the whistleblower makes using publicly available information. The information also cannot already be known by the SEC or the CFTC. And very importantly, and this is a feature also in the False Claims Act, though with some exception, is that it can't be out in the public domain already. And that's to stop parasitic actions. There's some very kind of signature precedent in the False Claims Act area where an individual read the New York Times that the government was going to be filing an indictment, a criminal indictment, and an individual, without any knowledge of the fraud, ran to the courthouse and filed a civil complaint. So when matters are out in the public domain, a whistleblower will be prohibited from qualifying, or an individual would be prohibited from qualifying as a whistleblower. Also, very importantly, the SEC and CFTC programs spell out that if the information is in a manner that violates and is found to violate U.S. criminal laws, that person also is not eligible. There are further limits on who might qualify, the categories of people who might be excluded. So, just for example, employees of the SEC or the Department of Justice can't participate in this program. Officers or directors of companies, lawyers because of the attorney-client privilege, unless they're blowing the whistle on some other fraud. Foreign officials may also not. There are some limited exceptions to these prohibitions. For example, if there's an ongoing crime or if the entity is obstructing justice, exceptions can be made. And then, as is true with the False Claims Act, individuals who are the so-called architects of the scheme, the so-called planners and initiators of the scheme, can't then enjoy a reward for the scheme that they implemented. As is true with the False Claims Act, another central feature of the Dodd-Frank Act programs is that there are protections against retaliation. And in fact, the SEC and CFTC programs have the strongest confidentiality protections, even allowing whistleblowers to make submissions anonymously. And I want to acknowledge Madame Ferrante's comments about the skepticism that anonymous submissions are regarded with. The Dodd-Frank Act wisely requires that an anonymous submission may only be made if an individual is represented by counsel, and counsel, in essence, affirms the accuracy of the accusations. A whistleblower can remain anonymous until the time of payment, and that at that point, at least to the agency, they become known. The agency does not publicize who the whistleblowers are, and that is because they recognize how powerfully whistleblowers might be retaliated against, that they may never work again. And while whistleblower anti-retaliation protections are very, very important, generally speaking, the remedies that are provided are not adequate to safeguard an individual for their entire career. They're really fairly limited. And if you can't work in your chosen career, that's a big sacrifice to make. So, like the False Claims Act, whistleblowers who are retaliated against may seek reinstatement and double back pay. There's been a very interesting development in the past year in this area, and this is fairly unique. The Justice Department has had the amended False Claims Act statutes with very similar anti-retaliation provisions for, well, it will be 30 years, as Ambassador Phillips noted, in just a couple of weeks. And they have always regarded the anti-retaliation remedy as a private right of action. And so that is true also with the Dodd-Frank Act. But the SEC has been very proactive, actually, enforcing anti-retaliation in individual actions because they regard it as a threat to its program. That when an employer retaliates against a whistleblower, that it has the tendency to discourage whistleblowing and to chill whistleblowing. And they've been very active in particular in scrutinizing employment agreements, severance agreements, confidentiality agreements, and have even taken enforcement action against companies where the SEC considers provisions to discourage whistleblowing. For example, prohibiting individuals from reporting to a federal agency, or allowing them to report to a federal agency, but then saying that they would have to sacrifice their financial award at the end. And within the past month, the CFTC noted that they too are going to be taking this very proactive view and be taking affirmative enforcement action against companies who retaliate. Now, it was very interesting. During the legislation, there was a very heated debate about whether whistleblowers should be required to report internally before going to the SEC or the CFTC. As you might imagine, the Defense Counsel were very supportive of this requirement, and whistleblower advocates were generally opposed to it. And one of the reasons why that is because, it's a matter of record, really, that most significant frauds are directed from the top of the organization as part of a business strategy. And in that context, even if you have an internal compliance program, it most likely is not going to be robust, right? So if you imagined if Harry Markopolos had been an insider in Bernie Madoff's firm, where the Ponzi scheme was being directed and implemented by Bernie Madoff himself, if he'd blown the whistle in that context, he would have been fired. And the problems would not have been disclosed. The Dodd-Frank Act came up with what I think is a very clever balance, which is they don't require whistleblowing, or rather internal reporting, but what they do is that they reward it. When it comes time to figure out the amount of the award, a whistleblower who reports internally will get a positive credit for that. And conversely, if a whistleblower impedes or obstructs an internal investigation, he or she will get a negative credit. But it is not required. That balance is there to encourage reporting. So I want to just very quickly compare the False Claims Act with the SEC and CFTC programs. The False Claims Act, as both Ambassador Phillips and Peter mentioned, allows whistleblowers to initiate an action in federal court on behalf of the federal government. In the SEC and CFTC programs, you do not do that. You do not file a complaint. You report to the agency. It's an advocacy piece that we prepare with the facts, with the law, with an investigatory plan, and that's presented to the agency. And also, unlike the False Claims Act, whistleblowers in the SEC, CFTC context do not have a right to pursue the action if the government declines to take enforcement action. However, the whistleblowers in financial fraud programs have the right to remain anonymous, while False Claims Act whistleblowers simply do not. All the programs have retaliation protections, and all the programs have a similar range of rewards. I just want to review quickly the kind of impact that this program has been having. As I mentioned earlier, in 2015 alone, 4,000 submissions were received by the SEC. And as this chart shows, the allegations concern just a massive variety of potential violation. Foreign Corrupt Practice Act, offering fraud, insider trading, unregistered offering, on and on. The results have been very impressive. In 5 years, the SEC has collected well over $500 million, and they've paid out over $110 million in whistleblower awards, including a $30 million award to an individual. I represented that whistleblower, and I can tell you a couple things. First of all, he was an international whistleblower. And then secondly, the fraud that was at issue in that matter concerned investors globally. In fact, probably the majority of the harm was outside of the United States, but of course the SEC could only enforce as to harms within the states. The CFTC, which has a much smaller program, it's a much smaller agency, has paid out about $15 million, including a $10 million award. One thing that's really been fascinating over the past 5 years with the growth of whistleblowing in the financial fraud arena is the real internationalization of whistleblowing. This map, the gold color, indicates countries where whistleblowers are making submissions to the SEC or CFTC and participating in those programs. And you will see Italy is colored gold as well. In fact, it's interesting, the number of submissions per capita. I mean, of course, the United States is number 1, but number 2 are the EU countries combined per capita. There, in terms of absolute numbers, China has more submissions than the EU, but per capita, they're more coming from the EU. So I want to shift gears just a bit and highlight the kinds of cases that we are seeing in my law firm, in our law firm, and many of which have global reach, even though they're being pursued by the U.S. whistleblower laws, and even though what's recovered only concerns damage to the United States, either the United States government or U.S. investors. One new area is cybersecurity. We have cases in that area. For example, violations of security requirements concerning the handling of extremely sensitive data by government contractors. Another concerns pharmaceutical products that are sold globally but are contaminated in manufacturing, or that are not manufactured to specification. We can only pursue actions concerning harms to the U.S., the federal government, for those contaminated prescription drugs that are purchased through U.S. healthcare programs, but those same drugs are being distributed worldwide. Another concerns manipulation of prices or rates for securities or commodities. And I'll give you an example. I don't know whether these are whistleblower cases, but I'm sure you're all aware of the massive damages and recoveries that have been collected in cases like the foreign exchange manipulation case and the LIBOR rigging scandals. Those are the types of manipulation cases that we are seeing in-house. Another type concerns defective military equipment that is purchased by governments around the world. Of course, we are only able to reach the U.S. government purchases. There are also a number of significant cases where there is no jurisdiction under U.S. law. As I mentioned, we're contacted by thousands of individuals every year. We have a very rigorous screening process. And one of the very first questions we ask is, can we bring this case under U.S. law? Does it fit within the False Claims Act, the SEC, or CFTC whistleblower programs? And sometimes we hear about cases, many from the EU, in fact, where they're really significant frauds, but where there's no jurisdiction in the United States. And I'll give you a few examples. Money laundering cases where EU banks are being implicated, but there's no SEC jurisdiction. Violations of regulatory capital rules under Basel III, where, again, there might not be SEC jurisdiction. There might be other U.S. jurisdiction, either Justice Department or Office of Comptroller of the Currency, but it doesn't fit within the whistleblower programs. Foreign bribery, where the SEC might not have jurisdiction over the entity. And again, situations where defective drugs are being sold globally, including in the U.S., but the U.S. government isn't purchasing those drugs. There's a very well-known over-the-counter painkiller where that is the case, and we were not able to bring that case. In all of these instances, and I haven't gone through all of them, each one of these individuals decided against reporting to their in-country enforcement agency. They came and contacted us and wanted to participate in the U.S. program for two reasons. One, the robust anti-retaliation provisions now backed up by the agencies themselves, and most importantly, the mandatory minimum financial incentives. It's very powerful, and generally speaking, although there are exceptions, the vast majority of people will not report because they are taking their livelihoods, and putting them at risk. So that's the end of my presentation. Do we have questions from the audience? Thank you. Thank you. That's good. Scream.
I just wanted to know what is the rationale for not being eligible for rewards if you're an officer or a director of the company in this last presentation.
Right. Yes. Yeah. So the question is, what's the rationale?
I think I should say it again for the
Okay,
translators.
okay.
Sorry about that. I asked what is the rationale for not being eligible for the rewards when you are officers or directors of the company in this SEC or CFTC cases.
Context,
Thank you.
Yes. Thank you for the question. The rationale is that officers and directors would already have an obligation to report. However, is in the context of an officer or director whistleblower situation that we often find one of those exceptions applies. So an officer or director generally is not going to step forward to us unless it's a very dire situation. So, such as the officer raised a concern internally, the company is bribing a foreign government official, he or she blew the whistle, that person was retaliated against, was marginalized, no action was taken, they're starting to destroy documents, anticipating that there might be a whistleblower suit. And in that context, an exception might apply to that individual. So there's an override in many of these instances. There's even an override where an attorney is a whistleblower. It's a very rare case. In my career, I've only represented one attorney. It's an active case. But it's a situation where we have a concept called the crime fraud exception, where an attorney may disclose privileged communications where there's an ongoing crime that could cause physical or financial harm to individuals. There's some other factors that also apply, but generally that's the basic rationale. Yeah, there's a question right there.
Yeah, it's a question on your perception. Do you think that... May I go?
Yes, I'm sorry.
On your personal perception, do you think that you would have the same amount of whistleblowers even if they would not be paid in the US?
Well, I think Peter would agree. Absolutely not. But
No, well, I think that what we base that on is really are two things. One is before and after, before the 1986 amendments and after the 1986 amendments. And the other thing is the way that the awards that have gone to the whistleblowers have created a large number of attorneys who are willing to take these cases and to take the chance of it because they will not collect anything unless they win the case. So there's a very big investment in these cases to handle them for 3, 4, 5 years or even longer. And so the awards create the incentives, not just for the whistleblower, but also for there to be lawyers who would be willing to take these cases. So I think we feel very strongly that in our situation anyway, that the award system is really at the heart of it.
Yeah, I mean, I think that's right. I think each of us had a slide really devoted to that, precisely that question in our presentations. And the before and after is really powerful. Even when a situation like with the SEC insider trading program, where you have weak incentives, it can really discourage people. You just see a massive drop-off. I'm told we have time for one more question.
I'll give you one more answer to your question from just a second ago. I was in charge of fighting healthcare fraud for the Obama administration, and much to my surprise, I found out that we did have a whistleblower program, and it had paid out $11,000 in almost 20 years because it was a very weak program, and so it generated no real amount of claims, and as long as it stays like that, it is not a source whatsoever of whistleblower tips because it just has too much negative side and no positive side. Thank you.